A misconception about the right to disconnect is that it means that an employer can't contact you outside of work hours. That's not what the right to disconnect is, at least not in its current iteration. The right to disconnect, rather than stopping an employer from contacting an employee outside of work hours, it's about the employee's right to refuse to read, monitor and respond to communications outside of work hours. It's about the response rather than whether or not it's been sent. However, that refusal needs to be reasonable. What is reasonable is going to depend on a number of factors, but it's going to depend on the level of contact, the reason for the contact, the level of disruption, whether the person is being compensated for additional hours or to be available outside of hours, for example, on an on-call roster, receiving an on-call allowance, the nature of their role and their level of responsibility and their personal circumstances. And until we've got some case law to sort of see what that's going to look like, we're not going to know how that's going to evolve. There is no salary cap, unlike unfair dismissal, so all employees in the federal system essentially have that right to disconnect. The right to disconnect has now become a protected attribute under the general protections provisions. If someone were terminated for exercising their right to disconnect, the employee could have grounds to lodge a general protections or unlawful dismissal claim. I always like to remind everybody that damages are uncapped for general protections claims.